Good morning, Mr. Linn. Oh, I'm so sorry. Well, I think Mr. Linn is going first, at least according to my clerk.
Successful applicant in a further appellate review, so I anticipate he goes first.
Well, Mr. Linn, why don't you proceed to go first?
Mr. Core?
I mean, Mr. Kaur. I apologize.
Good morning, Your Honors. My name is Kevin Kaur. I practice with the firm of Linn, Levine in Boston. I practice family law. I represent Heidi Emmons. This case involves more than just a dispute between formerly married parents. This case implicates the broader public policy issues that circulate around the child support enforcement scheme in this state. There is a strong and undeniable public policy that this state enforces, that all child support orders, all support orders, are to be enforced and enforced fully. And there's a corollary policy that when there is a default or breach by the obligated parent, that the cost and burden of the enforcement effort is not to be borne by the violated parent, but by the violator. Now, in this case, in this state, the Department of Revenue, at taxpayer expense, provides lawyers to represent people like Ms. Emmons, my client, formerly Mrs. Linn, against people like Mr. Linn, who choose to ignore and choose to violate and not comply with court-ordered support obligations. When private counsel, such as myself, undertakes to represent a child support enforcement claimant, private counsel is effectively performing the job that would otherwise be done at taxpayer expense in order to proceed and do the work necessary and reasonable to accomplish a successful child support enforcement outcome. That is what happened in this case. So private counsel in this context is effectively performing a public function. Now, the policies that circulate throughout this case and that support this case, I think, are best articulated in the case of Olmstead versus Murphy. It's a 1986 case decided by Justice Cass. And in Justice Cass's words, and in recognition of the policies in this state, Justice Cass wrote that there's legislative recognition that the legal expense of enforcing court orders permitted their evasion to the disadvantage of economically dependent spouses, often wives with children, and to the disadvantage of the public. And when the public has a particular interest in the vindication of a legal right, the market value for legal services based on reasonable expenditure of time and reasonable time charge should not be automatically discounted because it is high in relation to the amount recovered. And that the very purpose of charging legal fees in this context is to make certain that it is understood as a matter of policy that the defaulting spouse, that default, I should say, is unattractive and dangerous. The Department of Revenue, as a matter of policy and according to its publications, depends upon the private bar to step up in cases in which the Department of Revenue will not be involved because they involve such things as child custody disputes and parenting plan issues. That is exactly the context in which this case presented it to me in 2005. It was a custody dispute. Mr. Linn was seeking to change custody as a way in which to, in my view, intimidate his wife out of moving from...
Well, I think that may or may not be substantiated by the record, so I would ask that you keep to the record.
But the issue now before the court, Your Honors, is whether or not the appeals court was incorrect in its effort to deny appellate counsel fees. The denial of appellate counsel fees in a wholesale manner, as was the appeals court's initial approach, in my opinion, is a violation of the public policies that stand for the enforcement of child support orders in this case. And when the matter was sent back at Your Honors or at this court's suggestion to the appeals court for further consideration, the appeals court undertook to determine the fee and determined the fee to be a reasonable fee, additional fee for the appellate work done, to be 16.
You don't disagree with that number, do you?
Sorry?
You accept that number, is that right?
I do not challenge that number because I believe the appeals court had wide discretion to consider any issues they thought were appropriate in reaching the right number. My position before the court today that although I disagree that that figure of $16,571 is sufficient to indemnify my client under the contractual provisions that she and her former husband agreed to, it is an order that should be, an additional order that should be entered in order to at least compensate her partially for the successful efforts she had to endure with my assistance from the day the trial began to the day the appeal was completed. And unfortunately, I must recognize before this court that I hoped this would be the end. It's not the end. Mr. Linn has additional claims pending before this court. Justice Ireland denied a petition under 211, Section 3. That's now on appeal before the full panel, before the full court. So this is not the end of the case. And unfortunately, that's the experience that has plagued this case. It's never the end. The judgments enforcing the support orders have been enforced. Mr. Linn will come here today, will stand here today, and must, as a matter of fact, acknowledge that he has yet to make an effort to comply in any way with the
That's not before us, Mr.
Yes, Your
Kaur.
Honor, I'm sorry. In any event, given the appeals court's analysis, given the number that the appeals court arrived at, I think to invigorate the policies that this court stands for, that this state has in place, and the strong public policies, this court must guard against the establishment or announcement of a precedent that would either discourage people situated like Mrs. Linn from seeking out the advice and assistance of
Have you
competent, experienced
challenged the
counsel.
amount?
Sorry?
Have you challenged the amount? I thought your answer to Justice Botsford was no.
I don't.
Fine.
Or a precedent that would discourage counsel such as myself, when the Department of Revenue is not involved, from undertaking the work that needs to be done in these difficult and often emotionally charged cases. There's a quote, to use this court's own words, from 1975, causes for which advocates cannot be obtained are in effect non-adjudicable. And to discourage counsel from representation in cases such as this, or to discourage people who need representation from seeking out competent counsel, I think is a bad precedent. And with that, I'll submit on the papers I've submitted unless there's questions of the panel for me.
Thank you, Mr. Kaur.
Thank you.
Mr. Linn?
Thank you. May it please the court, my name is Peter Linn. I'm appearing today pro se. I've had such an extraordinarily frustrating and disappointing time in the probate court and the appellate court here in Massachusetts that I can no longer avoid the obvious fact that representation, both my own representation and representation that my wife has literally destroyed our ability to care for our children. You know from the record and the invoices submitted to you as part of the request for appellate fees that neither Heidi Emmons nor David Emmons have been paying Attorney Kaur throughout the appellate process.
Mr. Linn, the only issue we have before us is the issue of the appeals court's decision on attorney's fees.
Correct. When it comes to the question of attorney's fees, your order that you were going to allow further appellate review of this question refused to permit any other submission to the court, suggesting that everything was argued in the briefs. That precluded my ability to bring up and introduce to you one issue that I think is problematic in this case, and it's a matter of jurisdiction. You are aware, I assume from the stuff that's in the record, that there is a motion pending before the probate court addressing exactly the question that Attorney Kaur raised on appeal and then had the appellate court hear and now has before this court. He has a pending motion for reconsideration for the award of legal fees before Judge Rocket. There's no judgment on that. There's no denial on that motion.
But the issue here is appellate fees, not trial fees.
I understand that. The question, when you establish that you're going to hear a question on appellate legal fees, the presumption is that you're sustaining the award of legal fees on the probate court judgment.
No, there's no such presumption. Each court decides its own fees.
I understand.
So there's no presumption about any other decision.
But in denying my request for rehearing, which I specifically opposed the award of both probate court award of legal fees under a contempt provision and the award of appellate legal fees because the issue wasn't properly before the appeals court in the first place, in denying that application for further appellate review, it doesn't mean that you've upheld or affirmed the decisions of the appeals court. So those arguments, from everything that I read in the statutes and the rules of procedure, make those arguments part of the defenses against it at this court. You're not affirming or denying the decisions of the appeals court that they decided not to award appellate fees. In order to do that, that award of legal fees under the indemnification clause has to be sustainable. And there's absolutely no evidence that the case was ever tried under the breach of contract claim, because all you have to do in that case is review the transcripts, and you can't even get past the very first element in a breach of contract claim. You can't have a legally binding and valid contract when the evidence presented says it was all based on misrepresentation of income and misrepresentation of child care costs. You can't get to substantial performance on the claim because she's in breach of contract. She has a fiduciary duty to present that information. So the appeals court, in oral arguments, challenged the question and answered the question of whether or not attorney's fees in the probate court level were going to be awarded on the contempt.
They said they would be. They affirmed the award of the trial court fees, yes or no?
No. In fact, what the appeals court did was agree with Attorney Corr's argument that the finding of contempt in the probate court level was inconsequential to other findings that Judge Rocket issued. So they vacated the finding of contempt without vacating the award of legal fees that went with it. And then they proceeded to say the legal fees award should occur under the indemnification clause, even though the case wasn't tried under the indemnification clause. There's nothing in the record, there's nothing in the transcripts that says that. And in post-trial papers, arguments, and submissions, Attorney Corr has pointed out, specifically paragraph, page number, things that he is claiming supports the finding of the appeals court. None of that exists in the record.
Did you file an application for further appellate review?
I did.
And what was the decision on that?
Denied. And the stuff I'm talking about is included in that request for further appellate review. In terms of the attorney's fee award on appellate legal fees, I was surprised to find a case, and I've made no secret of my own disappointment in my trial counsel and my appellate counsel, but I was surprised to find a case in the files that addresses the award of appellate legal fees. It's Kroc versus Kroc, 1999. It's 46 Mass Appellate Court 528. I believe Justice Spina was on that panel, and I was amazed to find out that Attorney Kevin Corr was one of the participants in that case. In that case, the panel opined that in the award of legal fees, if a judge has substantial discretion in awarding legal fees on a contempt, a judge also has substantial discretion in awarding legal fees on a party who is defending a claim against contempt. The claim in the trial court, which was a contempt on a child support order, was not only vacated appropriately by the appeals court, but it wasn't properly before the appeals court in the first place, because that trial of contempt on the child support payment was already tried in 2003 by Justice Keamy. And Justice Keamy found me not guilty of contempt on that child support claim. So the double jeopardy rule applied before Judge Rocket. I'm not exactly sure how that slipped through and how he ultimately found the judgment of contempt, but I've also submitted to this court that erroneously or otherwise, the probate court clerks in the files handed me all of his original papers. I've submitted those to you If you'd like to have them authenticated, they're in the record. Not only are his handwritten notes about the judgment of contempt in there, but the 4 cases that he evaluated. They're all contempt cases. They're not breach of contract cases. They're not indemnification cases. So I'm not 100% sure how you get to a point in this legal process where you can say everything up until the point of awarding legal fees under the indemnification clause, you're going to accept and say that's done, and begin the question of attorney's fees awards. Because that implies that everything up until that point is done, over and litigated with.
If there are no further questions, thank you, Mr. Linn.
Okay.
Thank you.
All rise.